We take great pride in the immigration litigation part of our practice. Immigration litigation generally refers to judicial reviews before the federal court, as well as appeals and other proceedings before one of the divisions of the Immigration and Refugee Board. Our firm has successfully challenged temporary and permanent residency visa rejections, as well as the denials of refugee claims and other decisions in the immigration and refugee context. We routinely settle cases on consent with the minister, which means that the matter will be sent back for reconsideration without having to wait for a hearing. In certain cases, we're able to negotiate settlements which include specific instructions being provided to the next visa officer. This greatly increases the chances of future approval. I often tell clients with complex matters that while the application is addressed to a visa officer, the submission package is prepared in a way that will enable me to present their case before the federal court in the strongest and most persuasive way possible, should such a need arise. Why do I say this? Because on the judicial review, the evidentiary record is sealed, and a well-prepared initial application, therefore, allows to present a much stronger case before the court. Here are a few examples of the immigration litigation matters we've handled. We have successfully challenged the denial of an LMIA application for a game development company based on an unpublished and internal memorandum. In my view, the denial constituted a clear breach of procedural fairness. I convinced the client to challenge the decision in federal court. The matter was settled on consent within 10 days of the application record being filed, and a positive LMIA was issued within several days of the settlement. Our client proceeded to hire the worker it needed to grow its operations. That worker has now become a Canadian permanent resident. In another case, we challenged the rejection of an owner-operator LMIA-based work permit application for a startup company. The case was again settled on consent. After the settlement, we prepared a supplementary submission package with respect to the work permit application. The work permit application was approved. Our client was able to enter Canada, commence full-scale operations, and is in the process of submitting his permanent residency visa application. In addition to helping our clients and protecting the integrity of the system, our litigation practice enables us to prepare initial applications to a high standard, as we see the big picture and are able to anticipate and deal with issues preemptively. While this takes more time, we're a boutique law firm and take great pride in providing excellent service. It is important to note that even though we take pride in our litigation work, we always start with assessing your case. Litigation may not necessarily be the best path forward. Sometimes it makes sense to reapply, addressing the issues that have led to the rejection, or file a reconsideration request. Whether you're thinking of submitting an immigration application or are looking for a lawyer to help you challenge a rejection, we're here to help.